first case is State of Ohio versus Donte Burst. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I will be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Your Honors, may it please the Court, Attorney Donald Pond, on behalf of defendant appellant Donte Burst. We appreciate the opportunity to be here this morning. Respectfully, counsel would ask to reserve 3 minutes for rebuttal. We arguing here this morning a technical reading of the revised code section 959.131E2. The assignments of error all revolve around the meaning of that statute, in that the court and trial counsel misunderstood the meaning of that statute, in that the court issued erroneous jury instructions, and counsel failed to object to those jury instructions. And in terms of the sufficiency and weight, there was no evidence presented that Mr. Burst was operating a dog kennel in Summit County. Having said that, I draw this court's attention to a forest view, treetop view of the revised code section 959.131, because by reading that from a top view and looking at what the legislature is trying to accomplish with each section of that code, we can see that E applies to the status that one would have in relation to operating a dog kennel. First and foremost, a dog kennel, as it's defined, is primarily a profit-seeking function, or is otherwise registered under the revised code. That gives it a unique status under 959.131, and it has a different mens rea than some of the other sections there, A through D, and it has a different level of punishment. It's a felony 5. And in fact, when the statute was updated, amended, the conduct that was contained in E, 959.131E, then became 959.131F. Those two statutes after the amendment read identical, they're verbatim. So the legislature was intended that conduct regarding operators of a dog kennel will be subject to felony conduct.
Right, so E became F.
E became F.
And the subsections remained the same, however, and the language remained the same, and it was knowingly.
It's a knowingly mens rea, and it's a felony. And if we cannot separate the owner from dog kennel the way that subject reads in that, a sentence has a subject and a predicate. The predicate is the verb that describes the action of the sentence, what the subject is doing. The subject is you are either the owner, manager, or employee of a dog kennel. To remove owner from that meaning and connect owner in that section of the code to dog, then that means I could be an owner of a dog kennel, and as long as I'm hands-off and have no operation with the dog kennel, I just own it, presumably collect some money, profit, it's a profit-seeking enterprise, I can avoid liability under this statute because I'm not the manager or the employee of that dog kennel. I just own it. So we cannot separate the word owner from dog kennel. We can't take owner and connect it to dog, which is a description that is contained in the predicate. If the legislature wanted to do that, they would have defined things a little differently. They would have put no person who owns a dog or who is the caretaker, custodian of a dog, and no owner, manager, employee of a dog kennel shall knowingly, deprive the companion animal of the necessary sustenance. The rest of the language of E2, but really the focus is on what is Mr. Burst's status. The court missed it, counsel missed it, and there was a lot going on at this trial. First and foremost, it was emotional. As I was reading the brief, getting familiar, or reading the record, getting familiar with the exhibits, looking at what was going on at the trial court, it was emotional. The pictures are, that dog suffered. And he was sick, the dog was sick when Mr. Burst obtained him. He was already sick. Certainly there's an emotional aspect to that suffering, and that it was conveyed during the course of trial. It was a 4-day trial. It started on the 4th of January 2024. The jury rendered verdicts on the 9th. So that's a Thursday, Friday, Monday, Tuesday of trial. Very emotional. The parties had very contentious motions. There were several motions for mistrial, and that certain evidence was withheld, maybe not withheld. So there was a lot going on, and in that I'll call it trial chaos, that the court and counsel missed an important element of the jury instructions for this charge. And I think I've demonstrated the summary of the rendition of facts here, I believe, were more detailed than I would normally provide in a brief, whereas I went to factual background and factual summary that really go beyond the assignments of error. And I did that so I could convey to the court the emotion that was occurring at trial, and also that it was a very contentious trial, and that the parties covered a lot of ground with their testimony. But none of it, of the trial testimony, related to Mr. Burst's status as in relation to a dog kennel.
Is there any dispute that the defendant was not an owner, manager, or employee of a dog kennel?
There was no testimony of that. He's the owner of the dog.
Owner of the dog, but there's no dispute that he owns a dog kennel, is an employee of a dog kennel, or manages a dog kennel.
That fact is
Absent.
It's not only is it absent, that wasn't. I'm assuming it's absent because it's not his status. There was no evidence at all that he's operating the dog kennel. I think he had, in the trial testimony, he has 2 dogs at the time of the events. And so if we have testimony from the 2 veterinarians and the Humane Society agent for the state, and then we have testimony on behalf of Mr. Burst from a neighbor and also his girlfriend. If we go back to the Smith case, which was decided in this court, this decision rendered in 2017 out of Wayne County. It's cited in the appellant's brief. It's 2017 Ohio 359. Now that case, the underlying facts in that case was the defendant there was operating the dog kennel, and as part of the counsel in that case asserted a lot of arguments. I'll say counsel threw everything and the kitchen sink at the trial level and at the appellate level, and did not sufficiently develop some of those arguments. But in relation to how this court looked at 959.13, which relates to animals like cattle, poultry, any animal that's not a companion animal. You know, companion animals, for example, are dogs and cats. Counsel didn't develop that argument, but asserted that it was an equal protection violation because the conduct contained in 959.13 was the same conduct that was prohibited in 959.131. And this court said, no, hold on a second, there's additional elements that need proven under 959.131. You know, there's a distinction. First of all, we have animals versus a different class of animals that are given a higher status of protection, which is the companion animals, the animals that we keep close to us. And also, by the way, under 959.131E, we have to show, E2, we have to show that their status as an owner, manager, or employee of a dog kennel. So this court was very clear on that issue, even though the underlying facts there were that the operator, the defendant in that case, was operating the dog kennel. But we don't have that here. But nonetheless, that's the statute Mr. Burst was indicted under. And I would assert that the state issued that indictment because it moves it into the felony territory. The state easily could have indicted Mr. Burst under 959.131D, which identifies classes of all persons. You know, 959.131B, C, and D apply to all persons. And then all of a sudden in E, the legislature's saying, okay, we're going to apply E to operators, owners, and managers of dog kennels.
And you're running into your rebuttal time, just letting you know.
Okay, there we are. Thank you very much.
May it please the court, Evan DiMartino on behalf of the state of Ohio, the appellee in this case, we are asking that this court affirm Mr. Burst's conviction for animal cruelty under 959.131E2. The state would argue that the statute section, the phrase that applies to the owner, employee, or manager of a kennel is in the disjunctive and then says or custodian or caretaker.
I want to talk about that for a minute, because do you know how it's set up in OJI?
Yes.
So aren't there brackets on that full phrase?
The brackets separate out the owner, manager, employee, and then a separate bracket for custodian, caretaker.
The brackets do the phrase.
The whole phrase.
My recollection is the whole phrase.
Right,
And then there's commas in between all of those for each alternative within the phrase.
There's parentheses, right, with those sections.
With those
separated
sections
out.
separated out. So doesn't that read like the judge should pick the alternatives of a person who is involved with a kennel, not an owner and its own independent cause?
The way I looked at OJI, it looks like if they should give one set of parentheses versus another set of parentheses. Clearly, there's a a difference in opinion on how to read that section of OJI as well as this phrase.
Well, wouldn't they wouldn't need brackets at all if they weren't reading that clause together, right?
Maybe, I mean, I have seen brackets where I would maybe not put brackets, but I understand what you're saying. If they're there for the whole phrase, we would presume that OJI put that on there.
And doesn't new section E, the new section E, cover owners of a dog with the same other elements? Like new section E says owners recklessly didn't provide sustenance or whatever that exact language is. And then new F is owner, employee, manager of a kennel.
You're talking about the 2023 section that was not
Right.
in effect for birth, but is in effect now, right?
Correct.
Okay.
So doesn't that, the new section E would cover someone who doesn't work at a kennel. This one would cover people who work at a kennel. And new section E would be the F5, I mean, the M1, and the old section would still be an F5.
So new section F has the language that would be in E2, so there's F2,
Right.
same phrase. And then E talks about reckless.
Right, versus knowing. And the judge in the jury instructions, even though the prosecutor moved to amend it to an M1 without changing the language,
Right.
gave the instruction of knowing in the jury instructions, which isn't E or the M1.
The knowing section in the version of the statute that was in effect in 2021 would have been knowingly for causing unjustifiable pain or death.
Right, but the new section F is still an F5.
Correct, but it was not in effect for burst.
Right, so she would have had to have read E2 as no, she didn't go to E1, the new E, obviously she's using
Correct.
the knowing, okay.
And the new section talks about for owners recklessly, and it knocks down that mens rea, but the language with regard to death is still only in F2, the death, which would be, my understanding, the reason of why the prosecutor used the E2 section as opposed to another section, because in the 2014 version, which is what was in effect for Smith, it was a completely different section. It talked about omitting any act that would cause unjustifiable pain, which is clearly different language than what's at issue in burst, or what we're talking about in the new version of the code. This language that we would be talking about in E2, which is now in F2, was in D2 back in the time that the Smith case was out. But I say all of that to say that when the 2014 statute that was in place during Smith didn't have a provision that talked about knowingly causing, by not giving water or food, a situation that could cause unjustifiable pain or death. That did not exist. Then in the statute that's in effect during Burst's case, that's the only section that applies to knowingly causing death, to put it, just kind of narrow it down like that. So if this court takes the construction that it only applies if a kennel owner, manager, or employee knowingly doesn't provide food or water and that causes death, that punishment and prohibition only applies to kennel owners under that construction. And a companion owner, if they do something recklessly, they're punished, and if they do something negligently, they're punished. But if they're knowingly doing something like withholding food or water, and the animal has unjustifiable pain or death, then there would be no punishment for that. And that doesn't make, if you stretch it out, that doesn't seem like what the legislator was intending. In the most current version, the legislature...
Recklessly is a lower mens rea, so that would cover knowing acts.
But it wouldn't cover a higher prohibition or a penalty for causing death. It's just causing any type of pain.
I'm not sure I understand either. I was going to ask the same question to Judge Lanzinger. If you prove the state beyond a reasonable doubt that the owner knowingly did something, that would encompass reckless.
Right, but it's a lesser, just a pain. You're just causing any type of pain to the animal. That could be something that they could recover from. The language about unjustifiable pain and death is only in that E2 section. It does not exist anywhere else.
And that's the F5.
Right. So the argument would be that the language is in the
But there's
district.
an F5 that he was also charged with and not convicted of that would cover that type of conduct,
Right,
Just in a general way.
In a general way,
That would apply to owners.
it's just causing serious physical harm, which wouldn't specifically cover the acts of not providing food and water, which it does look like the legislature was trying to delineate out versus causing any type of serious physical harm to this idea of not providing food and water.
I have to say, wouldn't it be absurd to read that sentence as owner standing on its own when we have other parts of that clause that could not stand on their own?
So I
Like
would,
an employee of what?
right,
Manager of what?
I would take the phrase after the or, so owner, the kennel owner, manager, employee, or custodian or caretaker. Not saying the owner is the custodian or caretaker, just taking custodian or caretaker after the or, that would be the part I would argue is the most disjunctive. I agree, you can't just have the other two floating out there without owner, and there's commas there.
If we assume that that actually means owner of a kennel, could you argue that, or could you say the evidence is sufficient here?
There's no evidence that Mr. Burst was the owner, operator, employee of the kennel.
So in that circumstance, would we have to reverse on sufficiency?
Yes, there would be no evidence of that. So just to kind of go back to, I mean, this is a completely statutory analysis of whether 959-131, E2 as it's written now, F2, E2 as it was written when first was committed the offense, it would be F2 as it's written now. Whether that phrase was designed by the legislature to only include the kennel folks, or if it's also meant to include two groups, which would be kennel operators, employees, and managers, or custodians or caretakers. And that language continues to be in those sections of the code, and the state would argue that the reason for that is because the legislature intends for those particular subsections to apply to both. When it wants to just talk about the owners, it has said owners, which we would argue is evidenced by that reckless provision that's now in place to put that extra penalty on that lowest mens rea to apply to owners as opposed to kennel operators, employees, or managers. But with regard to the evidence, I won't go into the evidence. As long as there was a statutory construction that this individual fit within the prohibited persons, there is a great amount of evidence to support that this animal was suffered pain and died as a result of lack of nutrition. I'll only go into just a few things because opposing counsel did with regard to the evidence about the dog being sick. There was not really evidence that the dog was sick. The dog was negative for parvo. While the owner said that he got some deworming pills and that the dog wasn't putting on weight or wasn't eating, he also said, I'm not going to put any money into it. So the state would argue that there was no evidence that the dog was sick, just that the dog was very emaciated and subsequently died as a result of the lack of nutrition and lack of water, and the medical evidence that's in the record would support that. If there are no further questions, I would just rest on my brief on the arguments today with regard to the statutory construction of 959-131. Thank you.
We have 2 minutes and 32 seconds.
If we compare 959-131E2 and 959-131D2, D is the misdemeanor and E is the felony. The conduct, and D applies to all persons. The conduct in Division 2 in both those sections reads nearly identical. And we would submit that in D, the language is would become sick or suffer in any way. We would submit that dying is being sick and suffering. So having said that, I believe that there's consistency in what the legislature was trying to achieve. In addition, if the words custodian and caretaker here, they sound like nouns, but because of the linking verb, the be verb is, they function as verbs here. They're part of the predicate of the sentence of that code section, and the way the code reads is the caretaker, is the custodian. Those are reading like verbs. So the legislature just didn't grab onto what action you are in to be the custodian, without the be verb. That's part of our English language. We rely on these be verbs, and they're weak, right? We want action verbs, but it's a be verb. But the phrase is the custodian, is the caretaker, that is functioning like a verb, and in the predicate, and the sentence remains, we cannot break that up. We cannot separate owner from dog kennel. And that's just the only reasonable reading of that statute. And in a quirk here, I think in a sense, if the court goes back and looks at the jury instructions that were issued for D, the one that Mr. Burst was acquitted on, the judge left out element D as the definition of serious physical harm, which reads just like the requirement in E2 under 959-131E2. Had the judge put that in the first count, Mr. Burst may have been convicted on that count. And that's just a little quirk procedurally there that maybe he benefited from that oversight. So, and I believe I'm in 3 minutes. Thank you very much. Thank you for allowing us to be here. Have a good day.
Thank you both for your presentations. The court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision on the day it's released. Also, the opinions are posted on the Ohio Supreme Court website. Thank you again.
Thank you. Have a good day.